You, Mr. Oziums, told me we only need 2 hours. And I know better. I know better. So I scheduled it for all day.
Right from the start, Judge Mogen made it clear she wasn't here to waste time. Mr. Oziums thought 2 hours would cover it, but the judge had other ideas. She cleared her entire day for this case, sending a strong message. This isn't her first time dealing with drawn-out hearings, and in her courtroom, time is valuable. Then came 3 full hours of cross-examination.
I blocked my whole day off, knowing better, because it is taking Mr. Oziums, it's going to take him 3 hours to cross-examine Mr. Brimacombe. And then, after you're done, we get to move on to redirect.
Not just questioning, but a deep dive into every detail. Mr. Brimacombe had better be solid on his facts, because this kind of intense scrutiny means things are serious and the case isn't over yet. Redirect, recross, and possibly more witnesses are still to come. This isn't just a trial, it's a test of stamina at one point.
With Mr. Anderson. And then we get to move on to recross with you, probably for another 2 hours, of Mr. Brimacombe. And then we get to see if we have other witnesses. And then maybe you'll have a few minutes to provide your own testimony. Okay? So again, I would cut it a little bit short and I would get to the point a lot faster than you're getting. Because today's your day. All right? Because again, you only asked for a few hours and I gave you the whole day knowing better. So let's kind of do it a little quicker, okay? Next question.
Judge practically urged the attorneys to stay focused. She stayed respectful, but her tone said it all. Get to the point. When a judge has to nudge you along, it means you're pushing courtroom patience too far. This case involves multiple plaintiffs, LLCs, advocacy groups, and...
All right, we're going to address the 21 SC 179 first. And that doesn't involve you, Mr. Brimacombe, but you can be seated right there.
Thank you.
We will go on the record in the matter 21 SC 179, Michael Burton et al. Versus Carl Oziums et al., formerly doing business as Keeson's Enterprises LLC, Castle Advocacy Group Inc., Professional Services Corporation, and we also have Susan Oziums present as well. We're here today on the partial remand with regards to the attorney's fees on this case.
Corporations all tangled in a single lawsuit. It's not just about legal issues anymore. It's about money, power, and public image. And this is only the beginning. Now we hit a major point. Attorney fees. The Court of Appeals mostly agreed with the earlier decision, but sent it back over one issue, the fee amount. Simply put,
we have been waiting a significant amount of time on this appeal. The matter went up to the Court of Appeals and the court was affirmed, but it was sent back to the court as it relates to the attorney's fees. The Court of Appeals did state that as to the attorney's fees and the way that the court assessed the fees was appropriate, but in the amount of the fees and the fact that this is a case that went into significant litigation and had a substantial amount of attorney's fees, that there needs to be more information provided to the court in order to go over 3 times the award of damages to the plaintiffs. Therefore, the court does need more information from the plaintiffs and from counsel in order to proceed, unless the court is to rely on the statute, Wisconsin Statute 814.04(2)(a), where there would be.
Court felt the numbers looked too high. If the fees are 3 times more than the actual damages, the lawyers better be ready to prove every dollar with strong evidence. Mr. Anderson leaned heavily on his 2022 filings, but it's now 2025, and the court isn't accepting old documents as enough. The appeals court wants specifics, not a replay of old arguments.
The idea that it would only be 3 times the compensatory damages that the plaintiffs received. I'm going to first ask for arguments from both sides, and then, or if it is requested, to go into depth as to the specific factors. Mr. Anderson?
Thank you, Your Honor. I wasn't entirely sure what the hearing was going to be about today. I mean, I knew the topic, obviously, given the Court of Appeals decision, but I wasn't certain what the court would be looking for. We can go into the list of factors, although that may be broader than what we are prepared to all do here today in terms of if the court wants additional evidence or things like that. So I don't know if it's the right thing to go into that in detail. Generally speaking, though, Your Honor, in my September 27th, 2022 submission to the court, it was a lot of it is covered in that document. I'm not going to go through all of that again, but the court is well aware of this case. The fees in this case were reasonable given the time spent, and I know that's the time spent and the hourly rate that was charged. But what I think that the Court of Appeals may have missed in this one, Judge, is the fact that this was, I think, 3 hearings in front of Commissioner Krupa, a full day in front of Your Honor, motions filed by defendants that were summarily denied and dismissed, and ultimately, Your Honor, up on appeal to the Court of Appeals. Now, I will also say that the attorney's fees that have been awarded thus far in this case do not even include the attorney's fees to deal with the appeal filed by defendants. And I think that should be taken into consideration as well when considering the award of attorney's fees in this case. Your Honor, this case was, in my humble opinion, simply over litigated by defense. And what I mean by that is, again, I just sort of said it, 3 hearings in front of Commissioner Krupa, motions filed, a full day hearing, and really, Judge, the motions didn't really have any merit. I understand that the defense is pro se, but that costs attorney's fees to plaintiff when they have hired an attorney to deal with the motions that did not have any merit. Your Honor, the cross-examination in this case.
In law, the past doesn't carry weight unless it's backed by updated, clear details. Anderson argued the defense dragged this case out with extra motions and unnecessary hearings, turning the process into a mess. He says that led to high costs. But the big question is, was it really excessive or just thorough?
I'm going to stop you right there. I know all of that.
Okay.
That was in my decision. That went up to the Court of Appeals. And unless you're going to appeal to the Supreme Court, I can't overrule the Court of Appeals. And I will need the specific factors as they are directing me to go over the 3 times of the compensatory damages that were awarded to the plaintiff. Otherwise, I'm stuck with the 3 times the compensatory damages. The factors in Wisconsin Statute 814.045, and I used your letter brief when I did my decision because honestly, that's what I had, and I put in the information that this was, in your words, over litigated, and we had those multiple things. However, that did not appease the Court of Appeals. Therefore, we need more. They need more oomph.
That's what the judge has to decide. Judge Mogen's patience is running thin, she said. She reviewed all the briefs, followed the arguments, but still needs something strong and convincing to go beyond the standard fee limit. Without it, the court won't allow more than 3 times the damages. Here's where the law comes in. Wisconsin Statute.
Otherwise, again, we're stuck with that other statute, which just says the 3 times.
Then I would suggest and ask that a written submission be allowed to this court. I can have it done in 21 days.
All right, Mr. Oziums?
3 times the statute says 3 times compensatory.
Well, it doesn't say that that's what it's limited to. Is that your argument?
Yeah.
Okay. All right. Well, so I will allow each party to present their arguments based upon the Wisconsin Statute 814.045, which does have those specific factors identified, and then look specifically at Wisconsin Statute 814.045 paren 2A, which does go into where it states, in any action in which compensatory damages are awarded, the court shall presume that reasonable attorney's fees do not exceed 3 times the amount of the compensatory damages awarded by this presumption, but this presumption may be overcome if the court determines, after considering the factors set forth in subdivision 1, that a greater amount is reasonable. So unless the court can find that it is
814.045 says attorney fees should not usually go over 3 times the damages. But, and this is important, that rule can be challenged. If the legal team can prove, using the court's listed criteria, that a higher amount is still fair, the judge can approve it. It's tough, but possible.
Beyond, it is reasonable to go above the 3 times, then we would be limited to the 3 times the amount of the compensatory damages. I believe that the Court of Appeals decision is quite clear. Quite honestly, I thought I followed that, but the Court of Appeals wanted more, and that's fine. We do what we're told. So I will give 2 weeks for each of you to provide. How about 3 weeks? Is 3 weeks enough?
That makes it, with Memorial Day in there, it helps to have the extra week. So June 3rd-ish.
June 3rd?
That's fine by plaintiff.
Does that work, Mr. Oziums?
Yes, Your Honor.
June 3rd? And it shouldn't be very lengthy. We're just going over the factors and whether or not the court should follow that presumption of 3 times compensatory damages. All right.
Your Honor?
Yes,
May I say something?
you may.
So I am unaware of all this.
You were not a part of this. You may.
Your Honor, I think she was dismissed.
She, out of the first action, I believe you were dismissed out of the
Was I
first
a
action.
part of the appeal?
I don't believe you were.
No.
So I think you don't have to worry about that, that matter. You were just involved in the first part, but then you were later dismissed. And then now we're going to go on to the second case in which you are at this time a party.
And there's a key legal reminder. Just because someone wasn't involved in a recent round of the case doesn't mean they're off the hook. The judge gently reminded one party that while she was dismissed earlier, she's fully involved now. That's the risk with complicated lawsuits. You may think you're done, but the case pulls you right back in. Then came round to a new case, but with the same faces.
All right, we are adjourned on as to that matter. We will go on the record as to 23 CV 86. Rick Brimacombe et al. Versus Carl Oziums et al. Appearances are, we have appearing in person, Christopher Anderson, counsel for Mr. Brimacombe. We have Carl Oziums appearing without counsel, and we have Suzanne Oziums appearing without counsel. We're set today in this matter for a follow-up hearing to attain additional information for the court to be able to provide its final decision as it relates to this matter. We were set for a motion hearing and a contempt hearing, a damages hearing, and then a contempt hearing as it relates to the underlying issues. It was heard on February 4th, 2025. As the court was going through and trying to prepare its decision, there was some information that was still needed in order to finish or to continue with a full decision in this case. Therefore, I am going to ask the parties if they have any additional information as it relates to the damages. Because I believe that was a little bit lacking. I did get more information in the argument portion from the attorneys. I got some in testimony, but quite honestly, the arguments of both parties, even though I understand Mr. Oziums is a party / representing himself, that makes it a little bit more gray, because a lot of the arguments or information came from Mr. Anderson with regards to the damages. So I just want the parties to be able to.
This time, the focus is on damages and contempt. In simple terms, did someone ignore the court's orders? If so, what's the cost? This is where lawsuits turn into real consequences, possible penalties, and accountability. 1. Important note. The judge confirmed that plaintiffs can use
either provide a little bit more information as to the damages and or provide counter information to the damages, just so I have a better understanding. So if there are any, if anyone wants to proceed, this was your hearing or your motion, Mr. Anderson and Mr. Brimacombe.
Your Honor, are you looking for anything specific? I wasn't sure, coming up here today, I wasn't sure what the court was looking for the hearing itself. And so we have Mr. Brimacombe here. If testimony is needed, I wasn't prepared for a testimonial or evidentiary hearing, Your Honor. I wasn't sure what the court was looking for.
As to kind of like bullet pointing, you're asking for damages for A, for B, for C,
Okay.
and then the dollar amounts for A, for B, for C, and then what are they? Because it was kind of difficult
Okay.
the way the hearing went
Yeah.
the last time to be able to have testimony and then counter testimony, to be able to put that all together and formulate that into a decision. I could use the arguments,
Can I jump in?
but the arguments are from the attorney slash party slash attorney. Mr. Oziums?
Simply, there were no proven damages. They produced no receipts. They're just conjecture, guessing. I think I laid that out pretty well in my arguments, that they presented no evidence of any damages. They claim.
Well, Mr. Oziums, and here's so you can understand, the law says that they don't have to have receipts. They don't have to have those things. It can come from their own personal information and their idea. He could say, anyone could say, yes, I purchased this for $59.
Well, they didn't even prove that there was any damage. Not only did they prove no damage, they didn't show any type of a compensatory or any type of
And again,
evidence.
Mr. Oziums, that's for me to decide. And I have made certain decisions, and I have heard that there have been dollar amounts stated for certain things. And your testimony and your opposition that there was not any damage. And again, but most of the dollars, I've heard the damages that were being identified.
personal testimony to prove their losses. For example, saying I spent $59 on this can count as evidence. But the key is credibility. If the story doesn't sound solid, expect tough questions from both the other side and the judge. And finally, the big picture. Over $6,000 was spent.
And I heard dollar amounts, but for the most part, the summary of the damages came from the argument of counsel and the opposition in your opposition, Mr. Oziums. And that's why I just wanted to make sure that I heard correctly, unless if there is or there is not.
Yeah, and I can provide the list if you want. I can do it verbally right now, or I can provide it in writing, whatever the court prefers. But I think I can separate it out for the contempt piece, and then I can separate or from the nuisance part and the loss of enjoyment of property and the violations of the law, if you will, for renting the property and running a business on property that they shouldn't have been doing that on.
And that's where I think it got a little bit confusing and a little bit out of order. I'm trying to say this very tactfully, because it was not a very organized and controlled hearing. And so that's why I need it to be a little bit more organized and controlled. And I like that you have that, Mr. Anderson, but I would need a party to testify to that, and that we can have it as an exhibit, but then we can have Mr. Oziums contest that, and he can provide his opposition to that. But I just need to make sure that I have it all separated, what is being asked for as the contempt versus what is being asked for as the damages portion.
As far as the contempt, Your Honor, Mr. Alcium, or I'm sorry, Mr. Brimacombe can't testify to that. Ms. Haskins and Ms.
I have
Rotman,
that.
they testified. So the damages that we're asking for there are simply the amount of money that was paid by them to the Alciums.
And I have that.
Okay.
Then we're good with that part.
We're good with that. And then attorney's fees for that, and I have that at $2,970, Your Honor. I can provide additional detail, which I have not yet done. Wasn't sure what the court was going to do with
And
that.
then that's where you're going to have to come in and give me a specific statute that would allow me to provide you with those attorney's fees, because I'm going to follow the Court of Appeals decision, and I'm not going to, unless you have a statute for me that would allow it, as they state, you each their own, carry your own attorney's fees, unless you have a specific statute that would direct me otherwise.
I will get that to you, Your Honor, because it's a contempt. I think the court has the authority to do that, but I will get you the specific statute. I don't have it off the top of my head right now.
Okay. Because I don't want to run into the same issue with the Court of Appeals.
Understood. Understood. So that's on the contempt. You need anything more on that?
No, I do not.
Okay. Then on the nuisance damages, Your Honor, I can have Mr. Brimacombe go back up, but he testified to the
Let me get
out of
to my
pockets.
notes. I have
Okay.
as good of notes that I could with the way the hearing went.
Mhm.
So I can go directly to where Mr. Brimacombe testified. Yeah, I'm here. I have his notes right here.
Okay.
So you can present an argument if you wish right now.
Yes, Your Honor. So to start, there was a survey of $2,000. There was we'll call it a repair of the survey because of the removal of the stakes by the Alciums, and that repair was $600, and that was testified to by Mr. Brimacombe at the hearing. Frankly, Your Honor, there's a third time that was not yet testified to because it happened the day of the last hearing on February 4th, and the stake was removed again after the hearing by the Alciums. That is going to have to be fixed again. Your Honor, there are cameras that Mr. Brimacombe testified to. The cost of that, he testified, was $150 per camera, and there were 9 cameras. Your Honor, that amounted to $1,350. And then there was a repair of the camera that was damaged of $150 additional. Lastly, Mr. Brimacombe testified about the monitoring of the cameras being $2,160. The total for those expenses, Your Honor, as I have it now, without the repair or having the surveyor come back out for a third time, was $6,260. Those are the hard costs.
All right. Now let me just double check. I want to make sure that I have my notes.
Can I respond?
You will when I'm ready. See, I only have 8 in my notes as the cameras that were damaged.
On surveillance cameras, markers, and other tools to monitor the property. What started as a dispute turned into a full-scale defense system. This isn't just about a fence line, it's about how far people will go to protect what's theirs when they feel threatened. Real property fights don't just happen in court.
Well, there was
I have.
There
in
was
my
only
notes.
one camera that was damaged.
Well, I
just want to make sure we're speaking the same language.
I have trail cameras damaged. There were 3, but 1 was beyond repair. 3 that were close to the property and 1 at the end of the driveway.
And only the one was the one that required cost, Your Honor, to fix.
So there was only 1 that was really damaged.
One that had to be replaced. It was damaged beyond repair, I should say.
All right, Mr. Oziums.
None of those are a survey is not a damage. Repairing a survey marker doesn't cost $600 and is not damage. $1,350 for cameras. There was only 1 camera that they testified that was damaged, and again, there was no proof that that I damaged any camera, Suzanne damaged any camera. Monitoring of cameras, that's not damage either. Again, Your Honor, I just want to point out that this is not a real case. There's no damages. What they're basically trying to do is to get us to stop renting our property. They didn't provide any evidence of any damages, much less that I damaged anything or Suzanne damaged anything. These are pie in the sky, not damages. They're just numbers. Survey is not damage. Repairing a stake is not damage. And there's no evidence that I damaged the stake. There's no evidence of anything here. It's just all conjecture. There are no damages. Again, I would ask that their claims be dismissed because there are no damages here. Surveys aren't damages. Repairing and putting a stake back in the ground, it takes somebody to take a hammer and pound it back in. And again, there's no contempt. The county ordinance says 10 days or less.
We don't need to get into the contempt.
Okay.
Not there. All right, thank you, Miss. Miss. Oziums. I can't remember what your maiden name was. I'm sorry.
Beskar.
Beskar. Miss Oziums, do you have anything to say?
Other than I, as testified, was not involved, my name.
You don't have to say anything. You can say just you're relying on what you stated the last hearing. All right.
From that. Thank you.
Unless anyone wants to provide any additional sworn testimony, I think I have it. I just needed to make sure that I had what was stated at the last hearing and compare it to my notes to make sure that I had what was being asked for, because there are other things that were testified to that could have been damages, but they were not being asked for in a monetary amount, such as no trespass signs, and then the damage to that easement road, those types of things. But then there were non-monetary, I guess. There was no dollar amounts requested. So I just wanted to make sure that I was on the same page and that.
So, Your Honor, may I respond to what, maybe I don't need to respond to the specifics of what Mr. Oziums just said, but obviously we believe that they are damages. You have to get a survey to keep people off your property.
Correct.
Okay,
yes.
You understand our side on that?
I understand both sides.
The last piece, though, Your Honor, that I did not address, I was trying to take them in pieces, the hard cost, but then also the fact that my clients have lost the ability to enjoy their property while there are 15 vehicles and 18 people running around.
Yeah, I understand that stuff. I just needed to understand if nobody's seeking any monetary amount for any of the alleged timber trees that were cut, that damage to that big tree that was talked about, the no trespassing signs, the damage to the easement road.
That's because there were no damages.
I'm not talking to you, but, and the fact that there were perhaps discarded waste allegations, but for those alleged actions and alleged damages, there's no monetary amount sought. Is that correct?
It is correct with respect to a specific dollar amount, but all of that goes to my client's inability to enjoy their property to a certain extent. And those numbers are in our submission to the court from our closing argument, and go to basically my clients having to be the caretakers up there when the Oziums are 100 miles away, which I put in my brief is also a violation of Burnett County ordinance. And so all of that, Your Honor, goes to my clients basically working when they're up there at times, dealing with renters who are asking them questions, who are getting stranded on the lake, et cetera. And so all of that, again, goes to
Court. They play out with censors, receipts, and real-world tension.
$630,000 of ill-gotten gains that the Oziums received because they were running a business when they shouldn't have and where they shouldn't have. So there aren't specific dollar amounts that go with those, Your Honor, but it's all part of the overall claim but is my client's inability to enjoy their property and have this serene, tranquil experience that they expected when they went up there.
Okay, Mr. Oziums?
And again, that's nonsense. It's only a few weeks every summer. There are no damages. Again, they're just reaching. They're just basically trying to get us to stop renting our property. Not enjoying your property. Again, he was able to go to the property. He's able to get to his property. There weren't 15, again, the evidence shows there weren't 15 cars parked there. So again, this is all a reach. There are no damages. There's no contempt. And I've been in compliance with the 10-day order from last year and this year as well.
Okay, thank you. Now, the only other thing that I'm going to need then to wrap this all up is the argument for attorney's fees. And if you believe that attorney's fees should be granted, and if you believe that they should not be granted. Mr. Anderson is going to argue that they should be granted, and he's going to find a statute that says that there's authority to do so. And would you like to have Mr. Anderson file first and you do a response, or would you like it to be a dual filing, Mr. Oziums?
He can file first.
Okay. So, Mr. Anderson, do you believe that you can have both of your filings by the 3rd, or do you need additional time?
3rd's fine.
All right. So have both of your filings by the 3rd. And Mr. Oziums, your 21 SC case will be due the 3rd, but your attorney's fees matter will be due on June 10th. Is that okay? Or would you need till June 16th or 17th?
June 17th.
All right. So June 17th, your response can be due. Okay. So then that would be the last thing to wrap all of this up. And then I will have everything I need to complete my decision. Okay. All right.
If you thought this was just another case, think again. Every testimony, every question, every moment pulls the curtain back on the truth. And this is just the beginning. Tell us in the comments, who do you think is telling the truth? For more real courtroom stories, subscribe now to Ruling Today, where every verdict reveals a deeper reality.